All rise. Court's back in session. Be seated.
Versus Cavello, Jason Robert, 246858 FY, and he is present in court in custody. Mr. Manley present representing him. Ms. Rousseau Bennett for the Attorney General's office representing the people. Counsel, this is a pre-exam conference. Where do we stand at this point? I know Mr. Manley just got into this case, I believe, yesterday, having substituted in for Mr. Ellsworth. So where do we stand at this point, Counsel?
Good morning, Your Honor. Michael Manley. I also have co-counsel with me, Miss Sarah Koster, and we had the opportunity, Your Honor, thank you for giving us the opportunity to speak to Miss Rousseau Bennett in a break room. There is a number of things that we probably need to place on the record, and hopefully the court can give us some guidance on this. And with respect to our client, we received all the discovery up to this point that the Attorney General's office has. And I have worked with Miss Rousseau Bennett and Miss Hageman Clark in the past, always had great communication, which we had today. We also received a number of motions, pre-trial or pre-exam motions in this case, as it related to 404B admissions, 27B admissions, and actually the doctrine of chances that Ms. Rousseau Bennett has indicated that they intend to try to admit for purposes of the probable cause preliminary exam hearing. So at this point in time, and my client is aware of this because he knows the stakes of this are much greater than just a few weeks, we would be asking for enough time for us to review the discovery that we have gotten, review the motions and answer the motions that we have gotten, to consult with our client on potential defenses and other avenues, which may include a competency exam, as well as a request that he be examined to determine criminal responsibility based on some of the information that Ms. Rousseau Bennett has indicated to us that have been garnered through the discovery process or investigative process as it relates to our client. So at this point in time, we would be asking that the court adjourn the preliminary examination and set a date that we can argue motions. And I have explained to our client, because bond is always a concern with our client, that the judge that initially determined the bond in this case, that this court would have to find on an abuse of discretion standard based on new information. And we have no new information at this point in time. So the bond motion would be premature legally. So we would also like to have that motion date set for a potential bond motion, potential competency, criminal responsibility request, and to be able to answer the number of motions that the Attorney General's office has filed in this case. In speaking with Ms. Rousseau Bennett and going over their schedule, going over our schedule, and the amount that needs to be answered, and the sophistication and complexity of it, we would be asking the court for a date to argue motions in the week of January 20th, if that is convenient with the court. And I'll let Ms. Rousseau Bennett indicate if she has any other things to add or if I misspoke in any way from our conversations.
All right, thank you, counsel.
Thank you, Judge. Mr. Manley correctly recited everything that we spoke about in the breakout room. The people have absolutely no objection to adjourning the exam and proceeding forward in this fashion. I think given that they have just come on the case, they just received the people's other acts notice and brief, and the court has, I'm sure, seen it. It's extensive. It's lengthy. I think giving them enough time to review it to see if, one, they object, and two, if they object, to appropriately respond is appropriate in this matter. I think it's only fair to their client that they be able to address that, because that is evidence we intend to produce at the exam. As well as the discovery is voluminous. We're talking about 21 years of discovery here. And so I think it is appropriate to proceed in this fashion. I think we discussed the week of the 20th because that works with our schedules and gives Mr. Manley and Ms. Coaster enough time to appropriately respond should they need to, if that works with the court's schedule.
All right. So, Mr. Cabello, you understand what they're requesting here. The prelim is set currently right now for next week, December 23rd. Both counsel, your counsel as well as the Assistant Attorney General, are requesting that matter be adjourned so that we can sort through some of these other issues. You understand that? Yes?
Yes.
You don't have any objection to that? All right, court is going to find good cause to waive the 21-day and adjourn the December 23rd date. That seems most appropriate given the complexity of this case and the fact that Mr. Manley and his office just came into the case yesterday. As far as when we'll reset this, there we go. I was going to say, if it works with your two offices, we'll have you get in contact with my clerk, but she's looking at January 23rd at 1:30. On a tentative basis, does that look acceptable to both of you?
Your Honor, on behalf of our office, we're available to argue any motions on January 23rd at 1:30 in your court.
Judge, for the people, January 23rd at 1:30 works perfect. Thank you so much.
All right, then we will adjourn the preliminary exam scheduled for December 23rd next week, finding good cause to do so, waive the 21-day, and we'll reconvene for motions January 23rd at 1:30. Notices will go out. Anything further at this point?
No, thank you, Your Honor.
Nothing from the people. Thank you, Judge. I hope you and your staff have a great day.
You too. Thank you. Appreciate it. Thank you, counsel.
Thank you.
Thank you, Mr. Manley, Ms. Coaster.
Thank you, Ms.